Professor Dr. KVS Sharma, the learned Vice Chancellor of the National Law University, the learned members of the faculty, and my dear young friends. It's really a privilege and honor for me to be here today to share a few thoughts with you, all of you. I don't know how much of a pleasure it is for all of you to be called here on a holiday and then told that your holiday is deferred. Had I been in your place, I would have been cursing the speaker, but so be it. Uh, Madam said, I'm a product of the University of Cambridge. I'm not. She missed saying that I'm a product of the University of Guwahati. So my entire education was in Guwahati. I am born and brought up in Assam, a product of Don Bosco, Guwahati, Cotton College, Commerce College. And only I did my law in Maharashtra and thereafter practiced in Maharashtra. So here I am, more an Assamese, a born and brought up son of the soil of Assam who's here. So for me, being here is more like coming home. And we talk, a subject today which I've selected is constitutional morality and the evolution and application of the principle of constitutional morality. So we could make it a one-way lecture, or we could make it interactive if you all want as we go. We need not have the interaction till the end, and maybe you all can interrupt me and we can make it interactive as we go. But before I start, I would like to understand from you all what you all believe is morality. So is anyone amongst you who can share with me what you believe is morality? I'm sure one student from the National Law College of Guwahati would tell me what, according to him or her, is morality. No? Okay, then let me set it. Morality generally is a set of personal and social standard for good or bad behavior. That's basically a concept of morality, a set of conduct which differentiates between what is good behavior, what is bad behavior. A personal morality largely. Social morality, generally when we speak of, are a set of rules where a society expects you to conduct yourself in accordance with those rules for a peaceful and meaningful coexistence. So those are social moralities. And it is often said that morality is the quality of being good, of being right, of being honest, and of being expectable. And a lot of this morality is imbibed in us from our childhood. So when a parent tells a child, you should not be cheating in exam, you should be treating your friend with compassion, you should be treating your friends empathetically. Those are basically concepts of morality which our parents are trying to imbibe in us from our childhood personal morality, which our parents are teaching us. But a lot of morality also evolves from religion, religious tenets, religious scriptures. They also evolve a concept of morality. So when, say, Hinduism talk of pap and punya, when Islam talks of haram, when Christianity talks of virtue and sin, these are all concepts of morality which are tried to be imbibed in people following that religion. And there could be a lot of difference in the concept of morality of one religion to the other religion. Also, in a country as vast as ours, morality, the concept of morality, societal morality, the concept of religious morality varies from a small area to another area. Even in Assam, you will find that something which is so acceptable, in one tribe in an area is found abhorrent in other part. And that is true to most parts of India, that it is a thing which varies from area to area, state to state, community to community, and tribe to tribe. So there are so many flexible moralities. I wouldn't say it's flexible morality, but varying moralities depending on the social structure to which you belong. But there are certain values which you will find is kind of a common thread, which are found to be non-negotiable in any society, in any community. And those are general common morality principles which you will find in every community, every society: not to be cruel, to treat other human beings with empathy, not to steal. These are basic moralities, and there could be various other common moralities that you will find inflexible and common to almost every community, every religion, wherever you see it. So, this is a broad concept of what we understand as personal morality, societal morality, religious morality. And these concepts of morality have evolved with time. Things which were found to be an absolute norm some years back are today found completely not acceptable. There were various practices in our society, in Indian society, which were treated as normal, which were treated as moral, say 40 years back, 50 years back, 60 years back. And then came certain social reformers who taught the people the values, certain values which were so core to the human existence. We had reformers like Raja Ram Mohan Roy, Ishwar Chand Vidyasagar, and they reformed the society. And with that reformation, the concept of morality in Indian society also changed. So, somewhere where dowry was an absolute accepted norm of a society, nothing was found to be wrong with that, was started being considered as wrong, as not moral. Sati, widow remarriage, all these are concepts which changed over a period of time and shows that the concept of morality is always evolving, and with time, with thought, with maybe experience of what we have gone through with those practices, the society evolves, the community evolves, and with it evolves its concept of morality. And therefore, there is a constant change, a constant evolution of the society, of individuals, and along with it, their moralities. Now, when the constitution was being framed, the constituent as framers of the constitution, we were just a new nation. We had our own share of problems. We had our own share of difficulties bringing different states together, princely states together, each one of them having different culture, different set of norms, different set of acceptable values. And a nation came together suddenly where all these princely states with different values, different norms also came together. And each of these areas of which now formed a common nation had their own share of difficulties and different practices. And therefore, the framers of the constitution studied what are the ground realities, what is the social structure in India. They studied what are the practices which are today prevalent in the society, which are not really what they believed a way forward for an equal society, for a just society. And therefore, the framers of the constitution framed the constitution with a dream of bringing about an egalitarian society where people will coexist with justice, with fraternity, with brotherhood, and with liberty. And with this dream and vision, they encouraged the preservation of the individual rights of people, their culture and tradition of the different sections of people, the rights of people to practice their religion, but while preserving the individuality and the individual rights of citizens, they set out certain non negotiable principles which every citizen was expected to follow, irrespective of their caste, irrespective of their creed, irrespective of any part of the country that they belong to. And these non negotiable principles transgressed the individual rights of those citizens. The constitution framers gave certain individual rights to the citizens, which it expected the state to safeguard zealously, which you all are aware in the form of fundamental rights. At the same time, the constitution set out a certain code of conduct which it expected the citizens to follow in the form of fundamental duties. And it also set out a vision which it expected the state to bear in mind when they framed the policies of the state, that is, the directive principles of state policy. So they studied what was there which was wrong in our society and tried to correct it. They tried to bring about a situation where there will be no longer a discrimination on the basis of sex, on the basis of caste. They provided for affirmative action for the upliftment of backward classes. And these are various provisions which are really the soul of our constitution. And this is the spirit of the constitution. And it is these provisions which, read together, will form what is the golden thread that binds our constitution, that is the moral fabric of the Indian society as set out in the constitution. And that's where the principle of constitutional morality has evolved over the years, of finding out what really is the spirit of the constitution apart from the bare words of the constitution, what is the soul of the constitution, and then to consider the constitutional provisions in that light, not the bare words of the constitution. And that's where at some stage the principle of constitutional morality evolved. But the principle of constitutional morality was used for the first time in the 19th century by a British historian who studied Greek history called Grote. And he was a British historian who never went to Greece but wrote a 12 volumes on a Greek history. And Grote spoke about a statesman in Athens called Cleisthenes. Cleisthenes. And he was said to be the founder of democracy in Athens, in Greece. And it was in these times the nobles in Athens were yet to learn to respect the constitution. And this is what Cleisthenes worked on, to kindle a passionate attachment to the constitution. And this is where, for the first time, the term constitutional morality was used. So, constitutional morality, in the words of Grote, he set out basically two or three principles of constitutional morality, where he said that the citizens should respect the constitution and obey the authorities under the constitution. So, a citizen is expected to obey the authorities under the constitution and to respect the constitution. At the same time, the authorities, that is, the contenders of public power, should equally respect the constitution and act within the confines of the constitution. So, while the citizen should respect the people in authority, the people in authority should also not transgress their powers and should act within the limits of their powers under the Constitution. And the third aspect, which Grote highlighted, was that the citizens should have an unrestrained right to criticize the public authorities in discharge of their constitutional duties. So, this is the broad aspect of constitutional morality that Grote had evolved for the first time in the 19th century. And this is the first time when this term constitutional morality has been found somewhere. Thus, Grote evolved what policy? He evolved a principle of rights with responsibility. The citizens have a right, the citizens have a responsibility, while first of all, they have a responsibility to adhere to the Constitution. At the same time, they have the right to criticize the public authorities in discharge of their obligations. So this is where Grote had evolved the principle of constitutional morality. But when is it for the first time that this term constitutional morality was used in India? It was used for the first time in the Constituent Assembly debates when Baba Saheb Ambedkar was asked in the Constituent Assembly. Our Indian Constitution is one of the longest constitution in the world, and he was asked that why is it that the Constitution contains and incorporates so many administrative details of how administration should be run, of how the day-to-day conduct should be. Why should it has so many administrative details? That is not the idea, that is not required in a constitutional documents, and the administrative details could be left to the legislature to frame. At that stage, Baba Saheb Ambedkar quoted Grote and the concept of constitutional morality. And he said that only when citizens are saturated with constitutional morality that one can risk leaving the details to the legislature. So he said citizens must be saturated with constitutional morality so that you can leave aside the administrative details from the Constitution and leave it to the legislature. And he equally said that constitutional morality is not a natural sentiment and Indians are yet to learn it. And therefore, he said that it is wiser not to leave administrative details to the legislature and incorporate it in the Constitution itself. So, when you see the evolution of the term constitutional morality for the first time in India, Baba Saheb Ambedkar used it to justify the detailing of administrative details in the Constitution. And it was never intended to be a ground or a basis to challenge legislations which will be made in future by the legislature, as the Supreme Court has been doing. So this was the first use of the term constitutional morality by Baba Saheb Ambedkar. Now, that was in 1948-49. But thereafter, it was rarely used by the Supreme Court. One of the first references to constitutional morality was found in 1973 in the Supreme Court judgment in the case of Keshwananda Bharati. So first time in the case of Keshwananda Bharati, or that's one of the earliest references to constitutional morality by the Supreme Court, some of the judges in support of their judgment used the concept of constitutional morality. Justice A.N. Ray evoked the principle of Grote. He took Grote's formulation and he, in that context, discussed whether there was an inherent or implied limitation in the power to amend the Constitution. So Keshwananda Bharati had considered to what extent the Constitution can be amended. And Justice Ray had evoked the principle of Grote and Grote's philosophy while considering this issue. In another judge, Justice Jagan Mohan Reddy, had made reference to Ambedkar's speech in the Constituent Assembly while dealing with an argument that the Constitution reflects the will of the people and there is no limitation which can be ascribed to the power to amend. And Justice H.R. Khanna referred to this expression while giving an illustration saying, what if the legislature, by an amendment to the constitution, says that the existing legislature will continue for 75 years? He had said, will that be in accord with a constitutional spirit and constitutional morality? So, this was the first reference of constitutional morality by the judiciary in India. And that was in 1979, 73, sorry. After that, also, there was not much use of the term constitutional morality. And one of the vice chancellors of one of the colleges had said that it is against the morality of students who attend a lecture to be chatting. So please consider that concept of college morality also. I would request you all to consider that. So equally, in 1981, there was the case of judges transfer, that is SP Gupta. There, again, there was a reference to the concept of constitutional morality. And one of the judges said that violation of constitutional convention, which is neither enacted by the parliament nor enforced by the court, is a breach of constitutional morality and leads to grave political consequences. So, for the first time, the term constitutional convention, which is not enacted by a legislature and not really enforced by the court, was given a status of constitutional morality. And therefore, the SP Gupta judgment brought in a concept of constitutional convention. And this was really a concept which was also developed by Professor Dicey. So you will see how the courts have used constitutional morality in different sense. So as I said, after 73, one of the references was found in 81. So you will see that the extensive use of constitutional morality by the Supreme Court has only been in the last couple of decades and in the last maybe 15, 20 years. In between, till then, this concept was not used too extensively. So thereafter, it was used in some stray references in some judgments of the high courts. So in 1982, the Jammu and Kashmir High Court was dealing with a challenge to the Representation of People Act in Jammu, where certain disqualifications were put on people with criminal antecedents to contest elections, etc. And the Jammu and Kashmir High Court held that these restrictions were in the interest of constitutional morality. And these were passing remarks. Then the Patna High Court in 1985 said that there is a separation of power between the legislature and the judiciary, and there should be a restricted review of legislative action by the judiciary, and found this in accord with constitutional morality. Now, what was the first real use of this concept of constitutional morality? That was in a judgment in 2009 in the case of Naz Foundation by Delhi High Court. So Delhi High Court was, Justice A.P. Shah was one of the first persons to use extensively this concept of constitutional morality. In Naz Foundation judgment in 2009, Section 377 of the IPC was challenged, which criminalized consensual sex between certain people, and that too in private. Now, when this provision was challenged, the Union of India said that public morality is a compelling state interest which justifies this provision. So when this provision was challenged, the Union of India raised an argument of public morality as a compelling state interest which justified this provision under Section 377 of the IPC. Now, while dealing with this, the Delhi High Court distinguished between the term public morality and constitutional morality. So, what the judgment said was that popular morality, that is, morality which is popular amongst people, need not necessarily be the same as constitutional morality. And it said that popular morality is distinct from constitutional morality, which is derived from constitutional values. And it also said that popular morality is based on shifting and subjective notions of right and wrong. And it said that if there is any kind of morality that can pass the test of compelling state interest, it is constitutional morality and not popular morality. Moral indignation, however strong, is not the valid basis for overriding an individual's fundamental right of dignity and privacy. In our scheme of things, constitutional morality must overweigh the argument of public morality, even if it may be the majoritarian view. So, what he really said was that it is not just the public's popular view which will decide the constitutional morality. While dealing with constitutional morality, you must consider what are the rights which the Constitution thinks are the core of the values of the Constitution, which the Constitution feels and the Constitution framers felt cannot be compromised in any manner. And you cannot compromise those rights merely because a large section of the society feels so. And therefore, what the court really said is, however small a group of people it may be, if they have a right under the Constitution, that cannot be taken away by the majority of the population. And this was one of the first extensive use of the concept of constitutional morality in the Nas Foundation judgment. But this judgment was set aside by the Supreme Court in 2014. Though the Supreme Court referred to arguments based on constitutional morality, but it did not deal with it extensively. So the judgment of Delhi High Court holding Section 377 as unconstitutional, as affecting the rights of people to have consensual sex in the private, was set aside by the Supreme Court in 2014. And you will see as we go as to how our constitution also is really a living document, an organic document, and the constitutional morality and the constitutional values also evolve with time. So, certain things which the Supreme Court at a given time felt were not wrong. Today, with changing society, changing values, changing norms, the Constitution has also adapted itself, and the Supreme Court has also, in interpreting the Constitution, adapted itself and today held those acts in the modern society to be violative of constitutional morality. So, as I said, Nas Foundation was one of the earlier judgments which dealt with it, and that was, as I said, not too long back, 2009. So, we are what, around 16, 18, just less than 2 decades back. And thereafter, one of the judgments which came before the Supreme Court was in the case of Manoj Narula, where there was a disqualification. What was sought before the Supreme Court was that persons charged with heinous crimes should not act as ministers. This was an argument made by the petitioner before the Supreme Court. And Justice Deepak Mishra, while dealing with this issue, developed a concept of constitutional morality to mean that it is a concept to bow down to the norms of the Constitution and not act in a manner which would become violative of the rule of law or reflective in action in an arbitrary manner. So, Justice Deepak Mishra evolved a concept of constitutional morality as not to act in a manner which will be violative of the rule of law. But the Supreme Court declined to provide any guideline, pass any direction as sought by the petitioner. But while the Supreme Court did not pass any direction as sought by the petitioner, that a person with who is charged with a heinous crime should not act as a minister. While parting, the Supreme Court said that it had a constitutional expectation that the Prime Minister would not consider choosing a person with criminal antecedents against whom charges have been framed for serious or heinous criminal offense to become a minister in the Council of Ministers. So the court left it as a constitutional expectation and did not pass any directions as was sought by the petitioner. Then came in 2017. So, as I said, not many judgments detailing too much the real use of constitutional morality by the Supreme Court has been after 2017. It was initially in Keshwananda Bharati, then some references here and there. But effectively, the most detailed analysis started from 2017, firstly in the Shayara Bano case, that is where there was a challenge to the practice of talaq-e-biddat as violative of fundamental rights. Now, there the majority view did not deal with constitutional morality. But in a dissenting judgment of Justice Kehar, he used constitutional morality not to interfere with the practice of talaq-e-biddat. So the majority of the Supreme Court held that the practice of talaq-e-biddat was violative of fundamental rights. They did not use the principle of constitutional morality while holding that. But in a dissenting judgment, the Justice Kehar, while declining to interfere with the practice of talaq-e-biddat, evoked the concept of constitutional morality. And he said that the practice of talaq-e-biddat was a part of the personal law of Sunni Muslims and enjoyed a protection under Article 25 of the Constitution, and therefore could not be set aside on the ground of being violative of the concept of constitutional morality. So he said it's a personal right, it is protected under Article 25, and therefore could not be set aside as violative of constitutional morality. Now, thereafter, there was another judgment of the Supreme Court in Independent Thought versus Union of India, where an exception to Section 375, which carved out an exception for sexual intercourse between a man and his wife over 15 years of age from the definition of rape. So it was held that if a man had sex with his wife above 15 years of age, then that will not tantamount to rape. Supreme Court held this provision illegal and said this the Union of India justified this provision by saying that there has been a tradition of child marriage in India, and that has been performed in different parts of the country, and such a tradition should be respected and not destroyed. So the Union of India justified that child marriage was a tradition in a large part of the country. But the Supreme Court negated this contention. And this is for the first time, I would say, the Supreme Court observed about the constantly evolving concept of morality. And the Supreme Court said that with changing times, traditions and conventions are also required to change. In arriving at this view, the court found that apart from constitutional and statutory provisions, constitutional morality forbids them from giving an interpretation to exception 2 that sanctifies a tradition or custom that is no longer sustainable. Now, the court did not do a great deal of analysis of constitutional morality, but it applied this doctrine as a counterfoil to traditional morality. Now, pertinently, the Supreme Court did not go all the way. It did not apply this doctrine to the fullest extent, and it did not consider a situation whether the exception created for marital rape itself is illegal. So they said between 15 and 18 years, you cannot have this exception. But Supreme Court did not go all the way to deal whether marital rape at all can be an exception to the rape provision. And that is now, of course, being considered by the Supreme Court and is pending before the Supreme Court in a case of Rishikesh Sahu. So, an extension of the challenge to this exception is also being considered by the Supreme Court now. Now, thereafter, I'll take you all through 3, 4 more important cases, and then maybe we can have some exchange if any questions. So thereafter there was a case of K.S. Puttuswamy. So how many of you all are aware of the Puttuswamy case? Anyone who can tell me? Come on. Nobody knows about Puttuswamy case? It will be a dim impression of the National Law College University if no student speaks about a Puttuswamy case. They are all aware, sir, but they just don't speak. And I wonder, if law students don't speak, then how are you going to argue in court? Or you don't speak till paid. That's a early principle as a lawyer, that we don't speak unless paid. Yes, madam, please. All right, that is the right to privacy case, and one of the most essential cases where the right to privacy was evolved. But it was evolved in what context was the right to privacy developed? It was in relation to the Aadhaar scheme. That's right. So when the government came out, thank you. So when government came out with this Aadhaar card thing, it initially did it by way of an executive action. And there were certain executive directions issued, making Aadhaar mandatory and the entire practice of Aadhaar, and giving some of your details and particulars by way of executive directions. And it was challenged before the Supreme Court, and Supreme Court passed certain interim orders which prohibited the central government from compelling citizens to enroll in the project. That was an executive direction of the central government which was stayed. Now, while this stay of the Supreme Court was going on in relation to the executive action, there was a legislation enacted by the central government. So the central government, while its executive action was stayed, the legislature enacted a legislation now providing for a series of financial and other subsidies being connected with Aadhaar. Now, one of the issues which were pending before the Supreme Court was that when the Supreme Court had already stayed the executive action, could the legislature have legislated on the same subject and having the same provisions? Now, in a dissenting judgment of Justice Chandrachud invoked the principle of constitutional morality and said that the doctrine required the government not to act in a manner which would violate the rule of law, and they should completely and faithfully abide by the orders of the Supreme Court, which is the custodian of the Constitution. According to him, the non-compliance with the interim order of the Supreme Court was contrary to the doctrine of constitutional morality. So in a dissenting judgment, the majority largely upheld the scheme and the legislature. But in a dissenting judgment, Justice Chandrachud said that when we had already stayed the executive action, then the legislature ought not to have gone and legislated on the same subject when the stay was ongoing by the Supreme Court. Then the next judgment was the state of NCT versus Union of India, where there was an institutional conflict between the Lieutenant Governor of Delhi and the Council of Ministers headed by the Chief Minister. There were constant conflicts between the Lieutenant Governor and the Chief Minister and the Council of Ministers. Now, in this judgment, the Supreme Court extensively dealt with the principle of constitutional morality. Justice Deepak Mishra said that constitutional morality implies strict and complete adherence to constitutional principles enshrined in the various segments of the document. As per him, constitutional morality is the fulcrum which acts as an essential check against lapses on the part of governmental agencies which affect the democratic nature of the polity. So Justice Mishra said the constitutional morality means strict and complete adherence to the constitutional principles enshrined in the various segments of the documents. As I pointed out to you all earlier, in the judgment relating to disqualification of ministers being charged with criminal charges, Justice Mishra had said that constitutional morality means to bow down to the norms of the constitution and not to act in a manner which would be violative of the rule of law. But here he went a little ahead and said it is adherence with constitutional principles enshrined in the various segments of the constitution. Now, Justice Chandrachud, in this judgment of Lieutenant Governor, that is State Government of NCT versus Union of India, dealt with constitutional morality at length. And he said constitutional morality does not mean only allegiance to the substantive provisions and principle, but signifies constitutional culture. One of the essential features of constitutional morality was the ability and commitment to arrive at decisions on important issues consensually. Another feature of constitutional morality, according to him, was that it provided basic rules which prevented institutions from turning tyrannical. And he said that institution building is a facet of constitutional morality which requires that political conflicts are regulated through negotiations and accommodation, and that the constitutional morality provides a principled basis for understanding the work of governance, specifying norms for institutions to survive, and an expectation of behavior that will not meet the text but the soul of the Constitution. Accordingly, any constitutional interpretation must flow from constitutional morality, which is drawn from the values of the document. So he evoked constitutional morality to say that various constitutional authorities are expected to act in a manner that they will arrive at decisions consensually, they will avoid political conflicts, and they will be regulated at resolving issues by negotiations and administration. This is precisely, in fact, what Baba Sahib Ambedkar had said when he said, why I am required to provide administrative details in the constitution. So he had said that constitutional morality is yet to seep into the natural sentiments of the Indians, and therefore I need to provide administrative details. And this is, I think, what is reflected in Justice Chandrachud's judgment in the Lieutenant Governor's case. Now, I had told you all about the Nas Foundation judgment, which was there in 2009 and which was set aside by the Supreme Court in 2014. But this entire issue, as you all are aware, is opened again in Navtesh Johor's judgment in 2018. Now, therefore, the constitutional validity of Section 377, which was earlier held to be unconstitutional by the Delhi High Court, was now reopened since the Supreme Court had set aside the judgment of Delhi High Court. The larger bench of the Supreme Court now reconsidered the issue and upheld the view taken by the Delhi High Court in Nas Foundation. And therefore, in this judgment, the Supreme Court held Article 377 to the extent that it prohibited or criminalized consensual sex as ultra vires the Constitution of India. And in this judgment, there is a great deal of elaboration of constitutional morality. Now, once again, Justice Deepak Mishra dealt with this concept and said constitutional morality embraces within its sphere several virtues, foremost being the espousal of a pluralistic and inclusive society. It requires all three organs of the state to curb any propensity towards popular sentiment or majoritarianism. So he said that ultimately he went back to the concept of popular morality versus constitutional morality. And he said that the state and all its organs should not get swayed by popular concept of morality. In judging the validity of law, it is expected from constitutional courts to uphold the principle enshrined in the Constitution and not to be guided by popular perception or societal morality. So it said that you must ultimately see the Constitution, the provisions of the Constitution, what was intended when the framers of the Constitution included that provision, and not get swayed by what popular sentiments mean. Why is that so? Because a lot of concepts were popular even when the Constitution was framed, but the Constitution framers wanted to undo that because those practices were not practices which were furthering the cause of an equal and just nation. And therefore, provisions were included in the Constitution to try and undo those practices. If we keep getting swayed by popular sentiments and defeat those provisions, then the whole purpose of including those provisions in the Constitution would be defeated. Now, when the Constitution said that there should be no discrimination on the basis of sex, on the basis of religion. Now, if we get swayed by popular sentiments and uphold certain practices which lead to discrimination on the basis of sex, which lead to discrimination on the basis of religion, then we are defeating the very provision of the Constitution. And we are continuing with the vice which the framers of the Constitution had tried to undo by incorporating that provision. And that is what we need to bear in mind, that popular sentiments are not what are going to decide constitutional morality. The Justice Mishra further said that the concept of constitutional morality would serve as an aid to court to arrive at a just decision in consonance with the rights of citizen, despite how small segment of population may be. While testing the constitutional validity of any impugned provision, if the constitutional court is of the view that such provisions fall foul of the precept of constitutional morality, then such provision has to be declared unconstitutional. And if there is logic to it, just think of it this way: a popular sentiment, a popular concept of morality will always be dominated by the majority of the society. And then who is to protect the rights of, and when I say majority, I don't mean majority of any religion, I mean any majority section of the society. It could be the dominating men against women, it could be any majority, any dominating section of the society. So the popular sentiments is going to be governed by that dominating group, by that majoritarian group. Now, if that is to be treated as the test for morality under the Constitution, then the rights of the minority section of the or the oppressed group can never be protected. So you have to break that cloak of popular morality and identify what is really the spirit with which the right of equality was framed in the Constitution and try to achieve that. Justice Nariman, in fact, invoked constitutional morality to negate the argument raised by some of the interveners that it was open for the parliament to carve out exception to section 377, but the court ought not to take upon itself the guardianship of changing social norms. He said that the very purpose of fundamental rights was to place the liberty and dignity of the individual beyond the reach of majoritarian governments so that constitutional morality can be applied to give effect to rights. And constitutional morality, in his opinion, always trumps any imposition of a particular view of social morality by shifting and different regimes. Justice Chandrachud also extensively used a concept of constitutional morality, and he said that constitutional morality is different from public or societal morality. The latter, that is, societal morality and public morality, is determined by popular perception existing in the society, whereas the former, that is, constitutional morality, is determined by mental attitudes towards individual and by the text and spirit of the Constitution. He said that since the process through which the society matures and imbibes constitutional morality is gradual, constitutional courts are expected to act as facilitators and be vigilant against excesses of state powers. Insofar as the engagement of the document with law was concerned, Justice Chandrachud noted that no law can be divorced from constitutional morality. So, what did he really say? That the process by which a society matures and imbibes constitutional morality is slow and gradual, and therefore the court should act as the facilitator in this process and should be vigilant to ensure that constitutional morality is not defeated by any executive act or a legislative act. So the judgment in Navtej Johar, which was really one of the upheld Nas Foundation judgment, which was for the first time, as I said, constitutional morality after Keshwananda Bharati was dealt with at length by the Delhi High Court. So this around this period, as you see, 2000 after 2014-15, really the constitutional morality as a principle, it's then the extensive use of constitutional morality by the Supreme Court has really been in the last decade and a half. So next judgment is the adultery case. So what is the adultery case of the Supreme Court? Anyone who's conscious of the case in Joseph Sign? Yes, what is it? You tell me, madam. Come on. Since you are the vocal one, let's hear you.
The Joseph Sign case dealt with adultery, in which women were seen as the property or was owned in a way, in the language of the article, by their husband. So if another man was willing to engage in any kind of relationship with that woman in allowance with his husband, it was seen as fine. It was not seen as adultery. But if the same was done by a man, it was seen as an adultery, and it was
Right. So basically, a husband had a right to go and file a criminal case
yes.
if his wife engaged in a sexual act with another man or another person. So that was the case of adultery. And the Supreme Court, sit, ma'am, thank you. The constitutional validity of this provision was challenged before the Supreme Court, that is Section 497 of the IPC, which criminalized adultery, was challenged before the Supreme Court. And Supreme Court struck it down, primarily using constitutional morality as a principle, and said that constitutional morality will trump over societal morality. And Justice Nariman now dealt with this evolving concept of morality and said archaic law, which is based on paternalistic notion that likens woman to chattel, does not square with today's constitutional morality. So he said this is an archaic concept and this does not tally with today's constitutional morality, in that the very object with which it was made has since become manifestly arbitrary, having lost its rationale long ago and having become, in today's day and age, utterly irrational. He thus found constitutional morality as a facet of a test of manifest arbitrariness. Now, for the first time, constitutional morality was used as a test of manifest arbitrariness to consider a challenge to a legislation. So, a legislation cannot be challenged on too many grounds. One of the grounds under Article 14 is to establish manifest arbitrariness. And Justice Nariman now invoked the principle of constitutional morality and said what defeats constitutional morality is manifestly arbitrary. Justice Chandrachud also went into the concept of constitutional morality and said constitutional morality requires the assurance of certain rights that are indispensable for free, equal, and dignified existence of all members of the society. So, as I said, that there could be concept of a society, but does it tally with the concept of the constitution of equality between men and women, of equality under Article 14, is something which has to be tested, and that is what the Supreme Court did. Just one or two more judgments, and then I'll throw it open if you all have anything. The next very important judgment in the context of constitutional morality is the Sabrimala judgment. The Sabrimala judgment, where direction was sought against the state to permit women between the age of 10 to 50 to enter the Ayappa temple in Sabrimala, which was denied to them based on certain customs and practices which have been going on for a very long time. And the challenge involved an interpretation of the scope and content of fundamental rights under Article 25 and 26 of the Constitution of India. Now, what really is Article 25 and 26? Anyone who can tell me what is Article 25 of the Constitution? There must be fourth or fifth year law students here. Anyone who can tell me what is Article 25 of the Constitution of India? It's a right to practice your religion. The Article 25 gives a fundamental right to profess, practice, and propagate religion. And Article 26 says, right to manage religious affairs by religious denominations. So these are two religion-related rights which are conferred under the Constitution of India. But both Article 25 and 26 have made it subject to morality. The Constitution uses the term morality in 4 or 5 places. In Article 19(2, as a ground for reasonable restriction for freedom of speech, under Article 95 as a ground for reasonable restriction of a freedom to form associations, and in Article 25 and 26. So it was this whole interpretation of Article 25 and 26 as to what is your right to practice religion and what is it when it made subject to morality. What are the restrictions that are there to your right to practice religion? What is this concept of morality in Article 25 and 26? Chief Justice Deepak Mishra held that the term morality in Article 25 is nothing but constitutional morality. He said morality in Article 25 cannot be viewed narrowly in terms of what an individual, community, of religious sect may perceive to mean, but will imply constitutional morality. So the term morality in Article 25 and 26 was held to be not just general societal morality or morality of that religious sect, but constitutional morality. And he said that constitutional morality was understood to flow from the principles and basic tenets of the Constitution. So now constitutional morality is said to flow from the principles and basic tenets of the Constitution. And he said that public morality used in Article 25 has to be understood as synonymous with constitutional morality. Justice Chandrachud, in ascribing meaning to expression morality appearing in Article 25 and 26, also invoked the concept of constitutional morality and said that an expression morality in Article 25 could not be equated with social concepts which may be prevailing within the mainstream, but it should be equated and guided with constitutional morality. He said that the content of such constitutional morality can be discerned from the precepts of justice, liberty, equality, fraternity, and secularism. So Justice Chandrachud made a reference to the preamble while identifying what will be constitutional morality. And he said that the freedoms guaranteed under Article 25 and 26 must yield to these fundamental notions of justice, liberty, equality, fraternity, and secularism. And he said wherever there is a conflict between religious beliefs and faith with the quest of dignity, liberty, and equality, the latter must prevail. So it was a clear finding saying that if any religious belief is in conflict with the constitutional right of equality, of dignity and liberty, then it is the constitutional rights which will prevail over the religious belief and faith, and the restriction on a right to religion should be considered in that light. Justice Nariman, in his concurring judgment, he did not engage much with the doctrine of constitutional morality, but he gave a very interesting observation. Article 26 is not made subject to other parts of the Constitution. There are provisions and fundamental rights which are made subject to other parts of the Constitution. And he said that if you were to read morality in Article 26 as constitutional morality, then you are making it subject to other parts of the Constitution, which was never intended, because the Constitution framers here did not deliberately say subject to other parts of the Constitution. So he, to some extent, differed with the view that the morality is equivalent to constitutional morality in Article 26. Justice Indu Malhotra in this case. Now, just see, this is one part which I want you all to bear in mind as to who is going to decide what really is a constitutional morality. Justice Indu Malhotra gave a dissenting judgment. She said that no, this is an essential religious practice and the court should not interfere with it. So she did not grant relief permitting the women between 10 to 50 to enter the temple. But she equally evoked the concept of constitutional morality to negate the relief. She said that the constitutional morality referred to the moral values underpinning the text of the Constitution, which are instructive in ascertaining the true meaning of the Constitution and achieve the objects contemplated therein. She said that constitutional morality in the context of India, which is a secular polity, would comprehend the freedom of each individual group, sect, or denomination to practice their religion in accordance with their belief and practices. Accordingly, it was irrelevant whether the practice was rational or not. So she said that it is a fundamental right to practice your religion, and therefore constitutional morality requires that the court should not interfere with it. So the same concept of constitutional morality which the majority of the Supreme Court evoked to set aside that practice, Justice Indu Malhotra evoked the same principle to say that you have a right to practice religion and you should not interfere with it. And she said that although both equality and non-discrimination on the one hand and freedom of religion on the other are facets of constitutional morality, constitutional morality required the balancing of all rights to ensure that the religious belief of someone are not obliterated or undermined. In her opinion, such balancing would lie in favor of every individual denomination or sect to practice their faith or belief. So this is very important, and this is some thoughts which I would leave you all with. Now, this judgment was taken in a review petition later on. And while deciding a review or while filing a review, one of the questions which was raised was that there is no clear setting out of the contours of what is constitutional morality. It's something abstract which is being used by each judge in his own way, and therefore it requires a clear setting out of the contours of what is constitutional morality. And the matter was referred to a larger bench, and one of the issues which is framed for consideration of the larger bench is that the expression constitutional morality has not been defined in the Constitution. It is overreaching morality in reference to the preamble, or is it overreaching morality in is it overarching morality in the reference to the preamble or limited to religious beliefs of faith? There's a need to delineate the contours of that expression lest it becomes subjective. So this is one of the issues which has now been left open to a larger bench of the Supreme Court. And Justice Nariman, in this case, refused or gave a dissenting judgment declining to make a reference to a larger bench. And he said that constitutional morality, as expounded by different benches of the Supreme Court, was nothing but the values inculcated by the Constitution, which are contained in the preamble read with various other parts, and in particular, part 3 and 4 thereof. So, this was again a important issue which was referred to a larger bench of the Supreme Court. There are other references to constitutional morality in the case of the Citizenships Act judgment, then in various other judgments, small judgments. But one of the matters where morality has once again been evoked is a reconsideration of a 1962 judgment of the Supreme Court. Now, there was a Prevention of Excommunication Act of 1949, and that judgment was held to be ultra vires by the Supreme Court in the case of Sardar Sayyadna on the ground that it was a part of their religious practice. Now, that judgment of the Supreme Court has been reopened and is being reconsidered in light of the concept of constitutional morality, that can the power to excommunicate someone, is it in accord with the concept of constitutional morality? So you all will see that there have been a large number of recent spate of judgments which have gone and dealt with challenge to various laws on the ground of constitutional morality. And each judge has defined or described constitutional morality in different ways. One of the definition was that it is the spirit, soul, and constitution of India. So that was how one judge described it. One of the judges described it as adherence with the rule of law, adherence with the court's orders. One judge said that it is a test of manifest arbitrariness. There are different judgments. Justice Nariman ultimately said that the action should be in accord with the preamble read with various other parts of the Constitution, in particular Part 3 and Part 4. So, in the context of each case, how are we going to determine constitutional morality? Is it a risk that a judge can, being affected or influenced by his own concept of morality, define constitutional morality in that manner? Because think about it in a way that in a very same judgment, two different judges have used constitutional morality, one to set aside a judgment law and other to uphold the law. So how can there be such varying concept of constitutional morality when, depending on each judge, is constitutional morality left to be determined by each judge based on his own experience of life, on his own concept of morality, on his own test of morality? That is something which time will tell. And therefore, the Supreme Court has rightly and most importantly referred to a larger bench the issue that the contours of constitutional morality really need to be defined. Otherwise, we can lead to a situation that each judge will define constitutional morality and apply it to situations based on his own individual experience of life. And that may not be a very happy situation. Now, I would like to end it all with you on a note which I've always said, that when we talk of constitutional morality, is the furtherance of constitutional morality only the responsibility of the state? Or is it an equal responsibility of every citizen? Because right from 19th century, when Grote spoke of constitutional morality, he equally cast a responsibility on the citizens that they should abide by the Constitution and the authorities under the Constitution. So, in our day to day behavior, the Constitution of India expects the citizens of India to act in a particular manner. Now, when the Constitution of India gives a right of equality to a citizen. A state, of course, is expected to protect that right, to act in a manner that that right is not defeated. But is it not equally the obligation of a citizen to conduct himself in a manner that this spirit of the Constitution, this objective of the Constitution, to achieve an egalitarian society, of an equal society, a just society, is not defeated by the citizen in his day to day act? Because it is only when constitutional morality becomes a natural sentiment of every citizen that the objective of the Constitution can be achieved. So you can prevent the state from defeating constitutional morality. But when we say that constitutional morality can be at variance with popular morality, that means that the citizens are not developing a thinking which is in accord with constitutional morality. Because if every citizen was to question himself as to whether his own actions are in furtherance of the spirit of the Constitution, the spirit of a just society, the spirit of a society where people can exist equally with a sense of fraternity, then the question of a difference between popular morality and constitutional morality will no longer be there. Then popular morality will also become in accord with constitutional morality. And that is something which each one of us needs to carry with us, to consider that our actions in our day to day life should also be in accord with the spirit of an equal society, a just society, a fair society. It's very easy when we go down on a social media and express thoughts. We have to think whether my thoughts which I'm expressing here, is it in accord with the concept, with the Constitution we wanted to further? And if that is not so, should we not restrain ourselves from doing so? Because we, tomorrow, you all as lawyers, will be influencers of the society. You will influence the thought process of the society. And that is where I would call upon you all to, before developing a chain of thought, before developing a certain course of action, always question yourself whether your thoughts, your actions will contribute in achieving a society which is just, a society which is equal, a society where there is no hatred. And if each one of us can achieve it, then this gap between popular morality and constitutional morality will soon be obliterated. Thank you very much.
Sir, am I audible?
Yes, please.
Good afternoon, sir. I'm Priyansh Kanawat. Sir, talking about constitutional morality and religious morality. Sir, I would like to borrow from Dr. Professor Faizan Mustafa, sir, wherein he criticized the ERP test, the Essential Religious Practice Doctrine. Sir, being critical of the Supreme Court acting as a clergy. Sir, as you had also quoted Honorable Justice Indu Malhotra's recent in Sabrimala judgment, who opined the same. So my question to you is direct. How can and why should, if at all, constitutional morality dictate tenets of a religion?
You are right, but let's take it this way. You are absolutely right when you say that. But let's understand one thing. If a practice, what is the core of our constitution? What, according to you, is the primary objective that our constitution seeks to achieve?
So equal status of all citizens.
Equal status, a just society, an equal society where everybody can live with brotherhood and fraternity. Now, if there is a certain religious practice, see, there are a lot of practices, and I am not on any particular religion or in the context of any case. Historically, there are practices which are given a color of a religion and which defeat an essential principle of equality and justice. Now let's take it as sati. At certain time, sati was treated as an essential part of the religious practice. But with the development of the society, with various reformers of the society, the mindset of the society was changed, and it was found to be a practice which is not in accord with the norms of the society. So, religious practices at times, and that's where the fine, thin line is always a very difficult exercise of how much to interfere in a religious practice, an essential religious practice, on the ground of constitutional morality. And therefore, I said that constitutional morality requires a clear definition and contour, and we cannot leave it as an abstract sort of concept which can be utilized by anyone to disturb anything. So, to that extent, my answer is that religious practice which hit upon the various concepts of the preamble are something which the Supreme Court thinks need to be interfered with.
So, but shouldn't it be the role of the society itself to carve out such practice? For example, society itself had developed in such a way that it carved out such. But so for other religious practices.
But tell me something. Who gave, according to you, who are the people who created the constitution? The society. We call ourselves, we the people give to ourselves this constitution. So the constitution is really a document which is created by the nation and the people of the nation itself. And therefore, to some extent, the basic requirement of the Indian nation, the basic vision of an Indian nation, is set out in the constitution, which is created by ourselves. And therefore, when we are testing something against a constitution, we are not testing a practice against a document prepared by strangers. That is a norm prepared by ourselves.
Thank you so much, sir.
Yes, tell me.
Good afternoon, sir. Sir, I'm a first year BLLB student, and in our jurisprudence class right now, we are having an interaction of legal positivism and natural law. So, your lecture indeed was something which resonated with me. I have a similar question in that line, that in legal positivism, we have learned how important it is of legal clarity and certainty, right? And as you said, that constitutional morality is right now an abstract concept where every judge have his own concept and we all are using it in different ways. So in your opinion, in my personal bias I have here, that I am more of a legal positivist than a natural law. I do believe that natural law has its importance, but clarity and certainty is extremely important in a legal field. How in your opinion can we put certainty and clarity in something which is morality?
There is, honestly, I find it very difficult because, I must tell you one thing. There was a concept of public policy in the context, what is public policy? So the Arbitration Act allowed a challenge to an award on the ground of if it is contrary to the public policy of India. And the Supreme Court had said that the term public policy is like an unruly horse. Unless there is somebody who is, astride, who can control it, it can go haywire. According to me, the concept of constitutional morality can also turn out to be an unruly horse unless we control it and we define it very adequately and properly. Otherwise, it's very simple that any judge can elevate his own ideology and principle to the level of constitutional morality and say this is contrary to constitutional morality.
Sir, I have one more question, if you don't mind. Sir, you said that in last 10 years we are having a lot of discussion about constitutional morality, and with respect to all the judgments you have referred to, with Shahbanu, with Sabrimala, a lot of religious sites and religious uh, morality have been coming to subjection. I feel with this increased discussion with regards to religious morality and constitutional morality, the society of India is moving towards uniform civil code. And a very, very common thing which is, opposition which is given to people who support uniform civil code, as I am, is given that uniform civil code, abrupt minorities' right, or it goes against the minority culture. How do you defend that point of view, or,
As I said, everything is going to have two points of view. We are a diverse society where everything is going to have a different point of view. But when you talk of a uniform civil code as defeating the rights of a minority, you must analyze what the Uniform Civil Code contemplates. It is equally applying to the majority population as well as the minority population. And it is, if you were to think that the Uniform Civil Code seems to trust the traditions of a majority on a minority, that might be a different concept. But if there are a common set of rules which binds everyone, why should, see, let's look at it this way. Even earlier, different sects of Hindus also had different concepts of succession. There was then the Hindu Succession Act which came into play, which was equally applicable to various different parts of Hinduism also. So there is somewhere a need maybe that is felt by a large section of society of a commonality of rules which will bind every citizen of the country. And aren't there majority sections and minority sections in various other countries also? But they also have certain uniform rules which apply to everyone equally. So as I said, we need to be, when we debate about things, we need to be open to be convinced by the other side also. My thinking has always been that in India we are reaching a situation where a debate is just a debate that my thought is the only right thought. We are not willing to be convinced by the other side, and therefore any debate on the Uniform Civil Code by either side needs to be a debate with an open mind to be convinced by the other side, and that is what I would also request you to do.
Thank you, sir.
Good afternoon, sir. Myself Yashwardhan. I have a question. How could you differentiate between public morality and constitutional morality? My personal belief would be the constitutional morality could be said as the framers' the morality, or whatever you can say, like what the constitutional framers believed morality is, that could be said as constitutional morality. And is it so, like it could be different from the public at large, like
Let's look at it this way. Ultimately, when you say it was the morality of the constitutional framers, but it is this constitution which has held us together. Let's look at it this way. Tell me one country in the world as diverse as ours. Tell me one country in the world where so many religions coexist together. Tell me one country in the world where every 50 kilometers, it's almost like a different nation, the culture is different, the tradition is different. Tell me one nation where every 50 to 100 kilometers, the language changes. What has held us together? A nation as diverse as this, which came together only around independence, from small ruling states, etc., we came together. What has held us together from 1949 till now? It is this constitution which has held us together. And when you say that it is the morality of the framers of the constitution, as I said, the framers of the constitution were our representatives. They were the leaders who we thought were the people who show part to this country. And this constitution is not given to the nation by the framers. It was prepared by the framers. It was extensively debated, and therefore I would call upon you all to spend some time on reading the constitutional debates over a period of time, because those constitutional framers, if you see here, read the constitutional debates, you will see that they studied the constitutions of different parts of the world. They adopted some values from their constitution, but molded it as per the requirements of our nation. And a lot of doubts which you today have, you will find in the constitutional debates as having been raised by some other member of the Constituent Assembly debated and answered. So whenever you have a doubt as regards any constitution, issue, I would request each one of you all. There are volumes of the constitution debate to see that. So constitution is not a reflection of the morality of the constitutional framework. Tell me something. According to you, should there not be an equal society?
Should be.
Should it not be a just society?
It should be.
Should it not be a society where everybody coexists with equal, rights and as sort of in the brotherhood and fraternity?
Yes.
What else was the morality of the constitutional framework?
What I basically
No, I'm just trying to see. I'm not finding fault with you. What your thought is absolutely right, and that is what is often questioned. I'm just debating with you that what, according to you, is the morality of the constitutional framework, which is contrary to the popular morality today, because they have not provided any specifics. They have only said that there should be a right of equality. Now, it's for us to see today as to whether our practices are in accord with that principle or right or not.
So it could be basically understood as like constitutional morality is sitting at the top of the mountain where public morality needs to reach.
Absolutely, I would believe so. That, every conduct of every citizen should be there in a manner which will not defeat the absolute fabric of our constitution. Today, let's look at it this way. When you say popular morality, who is going to determine the popular morality? What does popular mean? The larger section of the society will determine, right? So let's look at it this way. In a society, 80% of the people are a particular class of people, and the 20% of the people belong to another class. The popular morality will always be determined by the 80%. And then they could evolve any concept of morality which will defeat the dignity of those 22% people. So popular morality is always dominated at times by the majority. And the constitution intended that the equality should not only be between the majority, it should not be determined by the majority, but every person should have a right to live with dignity. So that's where the test lies. Let's look at it this way. When we had a time of untouchability, you had a situation where a person used to be walking on the street, and a person who was untouchable had to go and stand next to the wall. Now, that was treated as perfectly moral. Who was deciding that? The dominating section of the society. And that is what the constitution wanted to undo when it said that untouchability is illegal. So a lot of concepts were pre-existing societal norms, being conscious of which the constitutional framework said, we must undo this. This is injustice. And therefore our future course of conduct should always be guided by that. That's my personal understanding of the situation.
So I can understand your point. I understand. I'm not saying untouchability was right or wrong
You
because
have to debate and exchange. Don't worry at all. You're meant to be a lawyer in future.
it is definitely not right. But the situation right where we are standing as a country, where we are shifting is the common notion between what's as I'm a student. The common notion between is going against basic principle of reservation. What reservation was meant for, it is not happening. The people who are getting reservation are not the ones who are.
Now tell me one thing. Is providing reservation and mandate under the constitution?
It is a step by the legislature
To further a constitutional principle of equality and achieving equality by affirmative action. Now, the constitution did not say that the state must provide reservation. It only enabled the state to provide for some special benefits and provided an exception in Article 15 and 16 if certain, privileges are granted to a backward classes of citizens. So the Constitution always believed that everybody should be equal, and it enabled a state to provide affirmative action. So reservation is not something which is mandated by the Constitution at all. It is the need which the legislature today feels is there. Your question, therefore, doesn't arise out of constitutional morality according to me. You are questioning the act of legislature. So according to you, let's take it further. According to you, providing of reservation defeats equality, is it? Or we have reached a stage where providing of reservation is defeating equality. Or that's a sentiment today in a large section of society. That's a sentiment according to you in a large section of society. Now, we have elected representatives today who are today much more glued to the ground realities. They have provided a certain element of reservation. Now, reservations are challenged in courts. Various kinds of reservations have been set aside by the courts, and therefore, from Indra Sawhney onwards, Supreme Court said that reservations cannot exceed 50%. That was the balancing of rights done by the Supreme Court. And when it was said that not more than 50% reservations can be there altogether, that was a challenge to the provision of reservation. And you read the judgments from Indra Sawhney onwards, and you will find a lot of answers to your questions on reservation. Okay?
Good afternoon, sir. I'm a third-year student here. So you talked about public morality and constitutional morality and how there is a fine difference between both of them. So I just wanted to know your opinion that how in the 2022 judgment of the Supreme case, where the question of same-sex marriage was, basically arisen out of different petitions. So I wanted to ask as to how we can put this concept of constitutional morality in that judgment, because the overall ratio of that case was that we cannot be providing even civil partnership or civil union between same-sex couples. So I just wanted to know your opinion.
See, the point is there, the court held really that legitimizing something and providing certain rights is the right of the legislature. The court said, I cannot provide rights to a certain married couple. So what happens? When a man gets married to another person, it is governed by a particular law. There is Hindu Marriage Act, there is other marriage, special marriage act, there are marriage acts. And they provide what are the consequences of those marriages. What are the rights which flow out of those marriages? In what situations those marriages can be annulled. Equally, there are succession laws which say that when a spouse dies, what is the right in another spouse. What the court has really held in that case also is that it is not for the court to legislate. Now, that would require the court to grant a mandamus and say that you must amend this act to include this. That is not something which the court could have done. But yes, to some extent, there is an issue of a larger issue of morality in that as to whether the same-sex marriage can be permitted or not permitted. It's a conflict between, constitutional morality and public morality again. And which way will the court read constitutional morality in this case, swayed by what principles, is something which time will tell. As I said, over a period of time, the same Supreme Court, which earlier held that 377 is constitutional, later on held it as unconstitutional in a gap of 10 years or so. So, therefore, as the court itself says, the concept of morality is perpetually evolving. For all you know, after 10 years, we'll have a larger bench reconsider it. After 5 years, you may have a larger bench reconsidering this issue and taking a different view.
So
may I ask a follow-up question
Yes.
then? So, sir, do you think in the event this country were to get a uniform civil code, will same-sex marriage be given the same rights as a marriage is given between heterosexual couples?
Neither the legislator nor
Yes,
the
sir, I just want
person in control. So my personal views are meaningless because ultimately that is something which only the code will determine. What the code will, I mean, what how the code is evolved is something which will have to be determined by the framers of the code. And of course, it will be open to all sorts of challenges in the court. So maybe you all will be there to challenge and to give it a little light.
Good afternoon, sir. My question is regarding caste census. So, how do you view caste census from the lens of constitutional morality?
In what way do you think it is either violative of constitutional morality or not violative of constitutional morality?
Basically, constitution talks about equality, and the thing is that everyone is equal in this society, and the government is providing Ashwini Vaishnav, one of the cabinet ministers, announced a caste census in this country, and after that there is an ongoing debate. So they are going to count different castes, and the thing is that they can divide the society as there are different fears among the upper caste and even among lower caste. And what happened about after the caste census of Bihar, they increased the reservation up to 70% in that particular state. So that is
Let me answer two things. Is it a reality in our society that we have different castes?
yes, sir, it is.
Is it a reality in our society that certain classes of people are backward and oppressed, or rather marginalized over the years, have not achieved the status of equality?
Yes, sir.
So, therefore, that's a reality which we need to be cognizant of. The Constitution provides for affirmative action. Now, to whom, which are the class of people to whom that affirmative action should reach, and to what extent requires a survey, study, and analysis. And therefore, that is being done even largely otherwise also. When any particular caste or class of people are to be declared, say, as socially and educationally backward class, there has to be a full survey done of what is the extent of population, what is the standard of living of those people, what is the standard of education of those people, what is the extent of backwardness of that people belonging to that class. This will only give us an identification, and that seems to be the objective. That will give us a breakup of what is the nature of population of a particular state or this country. To what extent each class has their own privilege? I mean, what is the status of each class in the sense of how much is the educational, backwardness, how much is the financial backwardness of any particular class of people, and considering that, affirmative action can be provided with an objective of reaching an equal society. So, caste census to some extent is intended to identify classes of people and make sure that affirmative action really reaches those people who need it.
Sir, but why we are not dividing or categorizing on the basis of different parameters like educational backwardness, literacy, and different thing? Why we are counting the like that in a particular caste? What is the level of backwardness? What is the level of literacy? So we can categorize in that manner also, right?
But see, there are historical backwardness and historical wrongs which are acknowledged and recognized by everyone. And it's a vicious circle. I invite you all to go through some of the judgments of the Supreme Court in relation to reservation. It is a vicious circle. Because of their historical oppression, they are not educated. Because they are not educated, they are not financially independent. So what you say is that there should be a bifurcation on different parameters. Let's take it. The Constitution bifurcates citizens, not really bifurcates or identifies certain sections of people who may need affirmative action. One of them are scheduled castes, who are identified as historically people who were marginalized, who faced oppression. And a presidential list is prepared of scheduled castes, and that is the scheduled caste. Then there are scheduled tribes, people who are in very interior parts, historically tribal people. A presidential list is prepared who require protection. Then the third class is what is known as socially and educationally backward class. Now that has various parameters. When you said that there should be parameters for identification of socially and educationally backward class, Supreme Court has set out various parameters which need to be considered. And if some class is declared as a socially and educationally backward class without this kind of a study, the Supreme Court has very often set aside their declaration as backward also. And the last class is now not a class but a section of society. I don't like using this word class. A section of society is now what is known as economically backward class of citizens, which is the EWS reservation. So therefore, the Constitution does to great extent identify which are the sections of society which require that protection. And the parameters for that are also now well set out in various decisions of the Supreme Court. Okay, sir, thank you. So it's not possible for me today to just declare any class and say to this class I will give reservation. If I do that, it is set aside in the code. Okay, sir.
So I have a question. What we want in our society, that there should be castes ongoing and people should feel that they belong to a single caste and there is a difference between me and on basis of caste, or do we require a society where people are thinking about their caste and something where people can think of better things, like not being fighting on, oh, okay, you are from my caste, okay, you are not from my caste, but the caste census would be defining this only, that okay, you are from my caste, somebody from a caste would say, okay, we are in large numbers, we can get reservations.
Without a caste census, are the people not thinking like that?
So, but like we could, what should be the step of the government? Make a way forward for the people to think in the right direction. Thinking of giving reservations on basis of caste is not right. Rather, if you give on basis of education, I believe that if what is said that lower caste are not economically forward, are not educationally forward. But if we just symbolically change the parameters, naming of the parameters like okay, you are from this caste, because of that you are receiving the reservation because you have a historic operation. I am not denying the historic operation, but if we just symbolically change the parties like okay, you are economically backward because of that you are receiving reservations, people might getting pushed forward, and I'm just saying.
No, I understand what you are saying is thought about by a lot of people. And it's an evolving world. Hopefully we get out of, we change the parameters over a period of time. Maybe over historically the affirmative action reaches the right people in the right way. We could head towards this situation which you are stating. Because look at it this way, today also, between the sections of society which are provided reservation, the creamy layer is being excluded. So you identify a class of people and take it from me. I ask you to read 2 or 3 judgments of the Supreme Court, where in what manner a class can be declared as backward is very well defined. It is not just on the basis of a class. It is that this class of people historically have faced problems, they have been backward. So you then go and do a full survey and study of why is it so. How many of them are backward? How many of their children have not studied, gone to school at all? What percentage of their population is doing manual work? What population of the children have studied up to graduation? And thereafter only that backward class declaration is made.
that's my basic question. Like, why do we want that there should be differences on the basis of the caste? It could be simply made on the basis of economy or other factors.
But that is also being achieved by EWS reservation now.
So that's a great thing, but I'm just telling differentiating society is.
I understand your thought process. I'm not saying no, but I'm sure at some stage we will achieve what you are saying.
Thank you.